Hello everyone, this is Tom Fox and I would like to welcome you to episode 62 of the FCPA Compliance and Ethics Report. Today I explore some issues related to self-disclosure under the FCPA with David Simon and Bill Athanas. I hope you enjoy this episode. Thank you. Hello everyone, and this is Tom Fox and welcome to this episode of the FCPA Compliance and Ethics Report. Today it's my distinct pleasure to have my two colleagues, but better yet, good friends, Bill Athanas and David Simon, and we wanted to visit with you today about some of the thoughts, issues, concepts, problems, and others that we see in the issue of self-disclosure. For those of you who don't know, David is a white-collar defense lawyer practicing in the FCPA and a wide variety of other areas, as is Bill, and I have not represented corporations in front of the Department of Justice, so my perspective is going to come from the more the compliance angle, but we thought between the three of us we might be able to put in front of you some of the concepts that we think are important. Certainly if you hear the Department of Justice speak publicly at a seminar, conference, or other event, they talk about the benefits of self-disclosure, and I think that those can be documented by the federal sentencing guidelines or other, in the guidelines. Some of the important criteria I think that the department looks at are really what have you done after you self-disclose, meaning did you actively come in and remediated it? And from what I've observed over the past couple of years, for the companies that have received the most reduction from the potential fines and penalties, it's really what did you do after you found out about it. But there are a lot of different other considerations, and particularly from a U.S. public company perspective. So maybe, David, I could throw it your way, and if you have found some general guideposts that you use or you would advise a company to consider, what have you done or what have you seen?
Sure. Happy to start it off. You know, I guess I'd say one thing just to elaborate on what you just said, Tom, about the Department of Justice's view of self-disclosure. And I think there's been a little bit of an evolution that I am a little troubled by personally. I think they have moved beyond the sort of encouraging self-disclosure to a much more aggressive stance that suggests, I think, that you will not get cooperation credit unless you do self-disclose. I think the messages that a lot of the last few speeches have been pretty direct and pretty aggressive on you ought to self-disclose or else, and I think that's a mistake. I think it's bad public policy, and I think it's frankly a little unfair. We don't have that expectation in really any other area of the criminal law. Not sure why DOJ thinks the FCPA should be somehow different. And two, I think, to me, from both an enforcement and a compliance perspective, I think there's real value in encouraging companies to deal with the issues and to investigate, to remediate, to put in controls to prevent the issue, from reoccurring, to, take disciplinary action as appropriate, to enhance the compliance program in a way to avoid the problem in the future. That's an important, and a good thing. And I think by overlaying this notion that any time you find something, you need to go to the government and deal with, months, probably years of further inquiry and investigation, years of additional expenditures on attorney's fees, incredibly negative publicity. I just think that's often not the best outcome. Sometimes it is, but often not. So, as a preliminary matter, I think those are some ideas worth considering. I guess in terms of answering your question about guidance, and I don't think there is any magical formula. It's every situation I've been faced with is very different. A big distinction, I think, is the difference between publicly traded companies and privately held companies. I think publicly traded companies have much greater incentives to self-disclose. Sometimes they're required to under the securities laws. Sometimes they're required to by their auditors. They're also facing a much greater risk of a whistleblower, coming forward with the information under Dodd-Frank. So I think that's a big issue to consider. I think some of the others are, how egregious and extensive is the conduct, and how aggressive was your investigation, and how aggressive was your response. Those are all I think important criteria to consider. But it's really, it's hard. It's the hardest decision you make in these things. It's never clear. It's never simple. It's never obvious. And I think you just got to work your way through those various criteria and make a reasonable judgment.
Bill?
I had made a note the last time we did this to make sure I try to speak first, because otherwise I have to follow David, and he takes all the good points. I agree with a lot of what he said, and much of what I've sort of just jotted down here as notes is follow-up. But I think the thing that really jumped out at me was the first point you make, David, which I think is absolutely correct: the evolution of the department's stance on this. And I think that some of that is born of the fact that as more and more of these cases come down the pipe, and we get more of a body of case law, as it were, not in the literal term, but more and more experience, then people are getting wiser about the value of self-disclosing and the circumstances under which you should do so. And I think there is very much a prevailing view, certainly in many of the people I talk to who are in-house, that self-disclosure is not should not be the default position. I always loved the quote that Howard Sklar used to reference, and it's a terrible shame that he doesn't write on this stuff anymore, but the quote I remember, and I actually wrote it down, was that failing to self-disclose is like putting one bullet into a gun that has 1,000 chambers and pointing it at your head. Self-disclosure is like putting 6 bullets into a 6-shooter and pointing it at your leg. And I think that's so true, and what we're seeing now is that many more companies are finding that it is worth rolling the dice on the first option, and I think there are a couple of reasons for that. One is, the government has taken the carrot and the stick approach here to try to encourage self-disclosures, and the most recent ACI conference back in November, there are some comments reported by Deputy Attorney General Cole where he talks about failure to self-disclose resulting in the DOJ pressure testing the results of a company's internal investigation and being unrelenting in the prosecution of those companies. I don't know exactly what that means, but it certainly doesn't sound good. And so I think that there's a real attempt by the government to use the threat of the stick to encourage more self-disclosures. The problem I think they have with the carrot is that it's really sort of not only undefined, but maybe undefinable. There are so many factors that go into these decisions, not only from the company side, but from the government side in terms of how to deal with it. And David, I think accurately listed many of them as you explore the dimensions of a particular set of payments or bribes or circumstances, as it may be. And I think it's very difficult for the government to say this is what you're going to get if you self-disclose. The closest they've really come is this notion of a one-level discount in charging decisions. That indictments, what would otherwise be an indictment, would become a deferred prosecution agreement. A deferred prosecution agreement goes to a non-prosecution agreement. Maybe a non-pros goes to a declination. Maybe you get no monitor. but it is all but impossible for the government to create any sort of binding framework in that regard, and that's really what clients are desiring in that scenario. They want to know, as we advise them and essentially try to forecast outcomes, what's going to happen if we do this. That's a really difficult thing to try to predict with as many variables as there are in the scenario, and without the absence of any sort of binding framework in place. So those are the challenges that I see in the process.
Well, let me just perhaps I'm not sure add would be the right word, but let me just throw out the following. In two major cases over the past 2 years, we did not see the companies self-disclose, and I specifically refer to Parker Drilling and HP. Certainly in Parker Drilling, we had egregious conduct, basically at the C-suite level. HP may have been more of a catastrophic failure of internal controls, but nevertheless, neither company self-disclosed, and yet they received discounts at up to 1/3 below the minimum the scheduling guidelines would have suggested for a fine or penalty. And certainly the government, I think, made clear that the reason they received such a hefty discount was the remediation that they engaged in during the investigation. Once again, neither company self-disclosed, and I had hoped to contrast that with Avon, who did self-disclose, yet did not really engage in, I think, during the pendency of the investigation, the extensive remediation and cooperation that HP and Parker Drilling showed. So it seems to me over the past couple of years, and even if you throw in Total and Weatherford, I think it's what did you do after you found out about it and you started engaging in cooperation with the government that seems to be the key factor now for a really hefty discount off the minimum range of the potential sentencing guidelines. Thoughts, gentlemen?
Well, I'll jump in real quick on one point that just sort of jumped out at me as you listed those names. HP and Weatherford were represented by Joe Warren, who probably, in my view, is the best FCPA lawyer in the country. I think that Joe probably identified some real opportunities for remediation and saw that as something that not only was a substitute, but more than compensated for whatever detriment there might have been for not disclosing. So I do think that it is encouraging and makes clear that you can, even if you self-disclose, still make up some benefit in the government's eyes throughout the process.
Yeah, I mean, I would agree with that. I think there's certainly room to make up some of it. I think it's fair to say that there is some additional marginal benefit to self-disclosure that you're not going to get if you don't self-disclose. I mean, I think it's, as you say, Tom, it's very hard to compare because there's so many factors in these the enforcement results are opaque, hard to compare, and are usually pretty general in what they say. But I do think I do think that really good remediation and corrective action, and then really good cooperation, if it does come before DOJ or the SEC, certainly can get you a long way. I don't think it can get you all the way there, though. I suspect if we had, this is just my instinct here, but if we had the ability to really, break it down and control for other factors, I think we would find companies get more credit if they do everything else right and self-disclose than if they don't.
Yeah, I would certainly agree with that as well. One of the things that maybe spoke to one of the issues you raised, Bill, is how do you really assess this, or how do you quantify it? And as I recall, there's 3 factors that are lumped together, which you can receive up to a minus number 5 on the scheduling. And those factors are self-disclosure, cooperation, and remediation. And so it's sometimes difficult to know how much credit is given for one or the other. And that's what's led me to really think that the remediation part is so important, because the companies that have engaged in extensive remediation seem to be getting the bigger discounts, even below the minimum suggested fine amount.
Yeah, I assume you're referring to, I guess it's 8C 2.5 of the sentencing guidelines, which contains those specific discounts. I think, though, clearly in the larger cases, that makes a difference, because the magnitude of the fines is so substantial. But for a smaller publicly traded, or even a significantly sized privately held company, I do think there's a perception that whatever benefit you're getting off that 5-level discount, at best may be a wash if you go in and self-disclose and the government says, great, you found this problem in Nigeria, but we see you're also operating in 7 other countries. We expect you to conduct your where else investigation and find out whether these are systemic problems and what else is going on in the company, and you're going to wind up spending in legal and forensic accounting and professional fees something 3 or 4 times what you might pay in a fine in a traditional sort of fat part of the bell curve FCPA case. I'm not talking about a Siemens or a BAE or something of that magnitude. And I think there's a real perception on the companies that, well, if that's the case, what are we really getting? Great, we're getting a 5-level discount on something that, by the way, may not even come to fruition if the government doesn't find out about this. And keep in mind, there were 50, whatever the number is, 50-something FCPA cases last year out of 9,000 criminal cases. Yes, we've had a significant ramp up in the number of resources dedicated, but there's still a small fraction of federal prosecutors who do FCPA work. There's a smaller fraction of FBI and IRS and ICE agents who do it. The government still has the challenges, even with increased cooperation with international law enforcement. They've still got to get the evidence. They've still got to go through that whole process. FCPA cases have gotten easier, but they're still really, really hard to do. And I think that companies recognize that, and many of them are willing to roll the dice. As David said, the odds are altered a little bit when you're a public company, because the opportunity for there to be problems are much greater. You got the whistleblower issue. You got scenarios where you may have to disclose, where you don't get a choice. But I just think that the people that I talk to in smaller companies, unless they see something really change in the enforcement environment, they're still sort of I won't say clinging, but of the mind that self-disclosure is not something. It's not all that the government. It's not all it's cracked up to be in the government's eyes. I'll put it that way.
And let me just follow up on one point Bill made, Tom. I mean, I have heard from a number of my clients that same issue about, what are they going to make us do, and how much are we going to have to spend to look at other parts of the world? I mean, if you conducted a good investigation, you will have looked at whether whatever the conduct at issue has the potential to be broader than you think, right? I mean, that's just competent investigation. But I think there's a perception among companies, and I don't think it's unfounded, that these sort of global trawling exercises are something that the government's going to require, and I think that's a huge factor in their minds about when they're assessing self-disclosure.
Let me see if I could change the focus a little bit to follow up on some of the things you've said, David. Say you're a board of director, and what questions should a board of director put to someone like yourself, outside counsel, or you, Bill, or what would a board of director want or need to know to really make an informed decision on whether or not to self-disclose? Can you maybe talk us through that?
Yeah, why don't I start on this one? So the first question that they should ask, and always do ask, is are we required to self-disclose, right? I mean, are we somehow breaking the law if we don't? And I think the answer to that's pretty clearly no, you're not obliged to, and then it becomes a more discretionary decision on what's in the company's best interest. I think the second question that gets asked and ought to get asked is how likely is this to come to the government's attention if we don't? Do we think there's a potential whistleblower out there? Do we either a true Dodd-Frank whistleblower or just somebody who might raise these issues and because they're a disgruntled employee or for some other reason, right? Are we potentially engaged in M&A activity that is going to create due diligence activity that is going to discover this and make us waive the privilege and disclose it in order to get a deal done? I mean, I think those are a set of questions that are important. I think the third thing that often comes up from boards is, what is the decision? What does this do in terms of my CEO and my CFO and my general counsel, my senior management? Are they, by now making a decision not to self-disclose, are they, risking their own sort of reputation? Are they, if the investigation reveals no involvement by senior corporate management, then they're put in a position where they have to make a decision not to self-disclose. Are they now all of a sudden part of this in a way that they wouldn't be if they could just say, hey, clean hands, I did nothing, I just passed this on to the government? And then conversely, if we do self-disclose, what does this mean for my senior management team? How much of their time and resources and energy is going to be spent dealing with the government for the next year or years and not doing what I want them to focus on strategically? So I think the questions are a little bit different from a board. Those are some of the things that I've seen.
Bill, do you have anything to add, or maybe if you don't, or you just have a few points? What do you think senior management would ask someone like you?
Well, I think one of the things they would say, what are we disclosing? Are we disclosing a complaint? Are we disclosing a suspicion? Are we disclosing a confirmed belief that we have actual violations here? It used to be that we had the luxury to wait, get your arms around the problem and understand how big it was, and then be able to make the self-disclosure decision in a more informed environment. I think that Dodd-Frank and the more generalized whistleblower concerns sort of throw that off. And there is a school of thought out there that says it makes sense to get to the government relatively early and say, we've identified this, so that you close off the possibility of a whistleblower, and also that you can talk to the government about the investigation you were planning and make sure that they're on board with the framework you've laid out, so that you don't spend a bunch of time and money and then have the government come back and say, we don't think you did a good enough job, do it again. The other thing I would expect them to ask is, who are we disclosing to? Are we okay just disclosing it to U.S. authorities, or do we have to disclose it to authorities in every country where we're operating to make sure that we're covered on that front? What is the nature or the extent of the disruption of operations to disclose versus not disclose? And then I think probably most significantly, what's it likely to cost either way? I think those are all questions I would expect in any scenario where disclosure were being considered.
Gents, we're near the end of our time. Any kind of wrap-up thoughts? Maybe we'll start with you, Bill, since you batted cleanup so far.
Sure. I probably would use my wrap-up time to just put in a plug for two resources I use a lot to deal with these issues. One is Martin Weinstein's book, and the other is Bob Tarun's book. Of course, it goes without saying that all the Tom Fox books are the Bible on compliance issues, but on self-disclosure questions, I find those to be the most helpful. Martin Weinstein and Roger Whitten wrote an article that I recall from 2010 that I still go back and use, and it's really just a terrific roadmap for analyzing self-disclosure issues, and I would commend it to anybody who's dealing with these types of questions.
And Bill, if somebody wanted to follow up with anything you've talked about today, could you give us your email address?
Sure. It's bill.athanas, Athanas, @wallerlaw.com.
David, any concluding thoughts?
Yeah, I guess the one thing I just would want to flag is, I really wonder whether this debate is going to look different in 2 or 3 years because of the rise, what I think is about to be the rise of the FCPA whistleblower. I think there are a couple of matters kicking around right now that potentially are generated by whistleblower complaints. I suspect it won't be long before there's some big dollar monetary awards to whistleblowers for bringing FCPA issues up. And I just think that has the potential to really change the environment in a way that's going to make us rethink our advice on self-disclosure. So I think it's just something to watch.
Wow, that's really interesting observation. And David, if someone wanted to follow up with you, would they be able to email you in some way?
Of course, it's DSimon, DSIMON @Foley, FOLEY.com.
And I guess my wrap up would just be maybe sort of summarize a couple of the things I heard you guys say, which is that if you go in and do a thorough investigation, if you can remediate the problem and really solve the issue that you've looked at, and that issue is ring-fenced in some territory, country, or other definable unit, it may be a very reasonable decision not to self-disclose. So I would just urge companies to, certainly an important decision, but it may be as good a valid decision not to self-disclose if your conduct to remediate and investigate it is thorough. So I think it's a very difficult situation. I hope if you're listening, you might get in this situation, call Bill or David or email them because they're two of the best I know of. I certainly learn a lot every time I talk to them, including today. Gentlemen, it's been great for us to finally get together on this topic, and I look forward to our next visit. So with that concludes this episode of the FCPA Compliance and Ethics Report. Thank you.